Thank you very much, Martin, and good to be here with such a large crowd and a pretty huge crowd, I understand, on the live stream, which is slightly intimidating. Apologies from Stephen Dunmore, the Chief Executive of the Fundraising Regulator. Stephen is recovering from an operation, doing very well, I'm pleased to say, and probably watching from the comfort of his own front room at the moment, so I shall be on my best behaviour. When we started out in January 2016, only 13 months ago, I think Stephen and I, sitting in a meeting room at the Charities Aid Foundation where we had our first temporary office, we recognised that the question of consent was going to form a major part of the work we would be doing as a new regulator. I think 13 months on, though, we hadn't then fully appreciated just how central the issue would be to fundraising by charities and charities working with their donors and supporters. I suppose you could say 13 months ago, for us, it seemed like a sort of little cloud on the horizon. It clearly wasn't for charities at the time, but over that period, it turned bit by bit into something of a perfect storm. The questions around processing of personal data and consents is certainly at the top of our agenda now as we do the things that we came into being to deliver. That's to develop and implement the fundraising preference service, consult on changes to the Code of Fundraising Practice, which we're doing at the moment, dealing with the caseload of concerns and complaints raised with us by the public, managing general inquiries, of which we get a huge number, and engage with all the many people and organisations with a direct interest in what we're set up to do. All of this has a core purpose, as both Elizabeth and Paula have said, and that core purpose is about rebuilding public trust and confidence in the way in which charities raise money from their donors. And we also need to make sure that that confidence, once restored, stays at a consistently high level once again. As a new, independent but non-statutory regulator, it is regulation by charities paying for regulation, we're committed to working together with our fellow regulators to ensure that charities are well equipped to deal with this key aspect of fundraising, the whole issue of consent and confidence. That, I think, is clear from what you've already heard from both the Information Commissioner and the Charity Commission for England and Wales, and I know this is going to be reflected in the seminars after lunch. As you've heard, we've put in place memorandums of understanding between the three of us, and we also have memorandums of understanding on the way with other organisations, the Institute of Fundraising, for example, and we will with the other regulators in the other countries too in due time. We also see ourselves as having a key role in taking on monitoring and reviewing how charities are approaching data protection and consents as they affect fundraising. And we're going to be doing that in our own way, but in full cooperation with regulator colleagues. The other part of that is, of course, to engage positively with charities and their representative bodies, as I hope we've tried to do from the very first day. I think our first, Stephen and my first meeting was, okay, who do we need to meet first? And we went off to meet the Institute of Fundraising, we went off to meet the then Public Fundraising Regulatory Association, and the rest followed from there. Our role is not to get in the way of charities fundraising. It has never been that. It's very much, as Elizabeth was saying, we're not the Department of No either. We're here to help make it possible in the best way that it can be made to work. We know from the inquiries that we get from large charities, small charities, and all sizes in between, that there's an awful lot of concern out there to get things right. And there's a lot of worry that the thoughts we had about how we might go about raising this money may not work. They may not be the right way to go about things. So we do have a very important role in helping people to get to the right place. We'll never do it for you. We're not in existence to clear people's materials or anything like that, but we are here to try and give advice and support. Everyone, of course, will be familiar with everything, I think, that's happened since the summer of 2015, and in particular, the work the Information Commissioner and her staff have been engaged on with several charities, whether that's been to monitor the approach that some were taking to consent and data protection for a short period before clearing them, or through to the monetary penalty notices and notices of intent that have been referred to already today. I think there's plenty of evidence that there's been an historical failure to pay attention to those important issues. We see that in the casework that we've been dealing with, and that's been particularly the case since we launched formally in July last year. We've seen it too in the casework and adjudication reports that our predecessors at the Fundraising Standards Board issued. We're also aware of complaints that have been voiced that in the past, perhaps, advice from any regulator was not always seen to be clear, perhaps not always seen to be consistent. But even if those concerns were justified, no one could be, I think, exonerated from responsibility to comply with and understand what the law requires. I think all that's happened has illustrated why fundraising needs to change and why it is changing. That's why the cross-party review of fundraising regulation in the autumn of 2015 recommended that a new fundraising regulator be set up in order to help streamline the whole process. It's also why the Charity Commission revised CC20 and the Information Commissioner has taken the action that she has. That said, many charities have certainly recognized the need to be sure they have the required fair processes in place for handling personal data, and they are checking that they have the specific consents they need to be sure they can contact their supporters and donors. Small side anecdote, by complete coincidence, through my letterbox on Saturday morning, I got a letter, addressed mail, from a charity that I do donate to, wanting to check that the consents they hold for me were up to date and what they should be. And it was really, really good, I have to say. I was very pleased to read it. They're asking, to check the details they hold about me. I know I've given consent to receive newsletters in the past, so I'm asked, do I want to continue to get them? How do I want to get them? By post, by email, whatever. It's all good stuff. So I take great encouragement from that things are changing, that people are recognizing that that has to be the case. We've heard too that NCVO has produced its report on consent, setting out recommendations and best practice examples. Whilst many charities, many larger charities, and some perhaps not so large ones, are reviewing how they seek consent, as I've said, and are making sure they review the data they hold alongside that. We know as well, and we'll hear more about this in a little while, some are changing the basis on which they contact donors. Opt-out models, opt-in models, moving from one to the other, perhaps. Today, we're publishing half a dozen case studies to show how a number of charities are going on that journey, how they're doing this. And you'll hear from a couple of them after I've spoken. These are just examples of the way in which the changes are being made. They're not designed to tell you how to do it. They just show what the thinking processes are, what the actions are that are being taken, that a number are doing. The 6 charities, I'll name check them because, as I say, they'll be up on our website if they aren't already there now. The Children's Society and Rethink Mental Health, who will be on show in a few minutes. Cancer Research UK, Macmillan, RNLI, and Rose Road, a smaller one. As we've heard from the Charity Commission, trustees need to be fully engaged with the ways in which the charity they have responsibility for raise the money they need. In our view, it's never been enough just to check the funds were coming in, the targets were being met. From the outset, trustees need to be sure that the approach to a fundraising campaign is ethical, it meets the objectives and the values of the charity, and fully respects existing donors as well as those new supporters that everybody wants to recruit. Nobody should be in any doubt, if you were, put the doubts away now, that the three regulators are working together closely, not just to identify poor practice, but to help charities put things right where necessary. For example, following the two recent monetary penalty notices, the Charity Commission and the Fundraising Regulator published a joint alert with advice to charities, and will do that again if the situation should demand it. When the ICO issues monetary penalty notices in relation to data processing and consents, or indeed anything else to come, we'll follow those up to ensure that remedial action is in place and that for the future there's not only compliance but some good practice to look at going forward. We'll continue to work with the Institute of Fundraising to encourage compliance amongst its membership, and we have a good positive working relationship there to do what needs to be done. There's also a great opportunity now for charities to deal with those issues of data protection and consent. Everybody has to be ready for GDPR in May 2018. Not long to go, actually, 15 months to that date. GDPR, along with the Fundraising Preference Service, when we launch it in the summer, will be transformative for donors and charities alike. I'd like to turn now to our guidance. I think that one, yeah, there it goes. Our guidance. We know there's been a huge appetite for practical advice on consent to be available. The number of inquiries we get every day about the code of fundraising practice, data protection, consent, just shows the demand for good advice. Sometimes it's perhaps people just seeking reassurance that what they want to do is the right thing. Sometimes it comes down to questions that are, can I go out in the street and shake a bucket? Well, no, you can't, actually, not without getting the permissions you need first. So there's that huge sweep of questions that we get to deal with. Where consent is concerned, it's why we've moved today to publish guidance about it on our website. It builds on information and guidance already available from the Information Commissioner, as well as NCVO's recent report and recommendations. All of it is intended to support the sector to make the necessary changes and to restore public confidence by doing that. You've also seen the Information Commissioner's paper for today's event that was spoken about earlier. We think that if you take those together, they should help equip you to begin to make those changes for GDPR coming in May 2018. Because we recognized we needed to move as quickly as we could in dealing with a really immensely complicated subject, we didn't consult in advance on the guidance published today, though some of the key organizations we work with did have an opportunity to see a work in progress draft. We do now welcome feedback on that guidance because we know there'll have to be a second edition when, for example, we know more about GDPR. We will have to reflect that in the guidance, very obviously, and we'll welcome comments that you've got about how practical it is to use. We can explore some of those issues in the seminar after lunch about that. So it's an iterative experience that we're going through here, and it will get better and better as it goes along. We also recognize that some may have different views about the interpretation of particular aspects of the law, but the ICO's guidance and legal interpretations stand for us, and as the fundraising regulator, we support them fully. I mentioned the Code of Fundraising Practice just now. We're currently consulting to the end of April on a number of changes to develop the code which we inherited from the Institute of Fundraising in July last year. One of the things that's not in the current consultation is changing the code to reflect changes to data protection and consent. We decided just to wait a bit on that because, again, we need to know more about GDPR, we need to know more about how you react to the current guidance we've put out there. So when all that comes together, probably a little later this year, we'll do a separate consultation about changes to the code on those aspects, as well as the fundraising preference service when it's ready to roll. We'll also, in that consultation, look at trying to incorporate in the code key aspects of those other good practice documents that I've referred to that are around. But the key thing about the code is that we've got to be able to turn those bits of guidance into those must-do rules that people can follow, and that, if necessary, we can make judgments against when things go wrong. We'll also publish guidance about what the fundraising preference service will and, as importantly, will not do when we're ready in the early summer when that comes along. And as I've said, we'll include requirements in the code about FPS as well. This afternoon's seminars will take those attending through the guidance and the key points of it in a series of slides, so I won't refer to any detail now. It's too long a document to do that in the time available. But the guidance is available on our website today, at least I hope it is, cross his fingers, and you can download it and look at it there, along with the 6 case studies. As I've said, those case studies show work in progress, the journeys that half a dozen charities are on, the challenges they face in making those changes, the risks, the problems of doing that. But it's all with the intention, one way or another, whether it's an opt-in approach or an opt-out approach, it's about getting to a better place with donors and supporters, and in the long term to securing the income needed to support the organisations. More from Rethink and the Children's Trust in a few moments. So where do we want to get to as a fundraising regulator, as the new musketeer on the block, to mix many metaphors? Sunlit uplands, I suppose, is what we're all searching for in the dark days of February. We want you to use the guidance and, in due course, the updated code as practical tools to make sure you're complying with everything that you need to comply with. We think the outcomes we want are those that you want as well. For example, not an exhaustive list, donors are treated ethically and with respect. Donors feel more committed to the charities they support financially or engage with in other ways, through volunteering or whatever it might be. Donors have given clear consent to the ways in which they want to be contacted, and that you as charities can show that if you ever had to prove it. There's clear evidence then for the purpose of those contacts and for any other purposes for which personal data might be used. At the extreme end, if for whatever reason charities don't deliver on this, donors have the option of opting out from contact with specific named charities through the fundraising preference service. But the bottom line on all of this, as I started out by saying, is that public trust and confidence in charitable giving is renewed and built on. We do understand, we do appreciate, and I'm a charity trustee too, so I'm aware of this in my other life, as it were, is that reviewing and renewing donor databases to ensure proper consents are in place is resource intensive, it does take time, and it may well, probably does, lead to a loss of income, at least in the short and medium term, if not the long term. It's not going to be pain-free, and I think the case studies do show you some of that. But it's unavoidable. There are legal requirements there, there is compliance there, and that's what, as regulators, that's your bottom line. You have to expect that. Our role will be to continue in a positive way to develop the code, work with charities as we learn from your experience as well. We will learn as well from the inquiries we get. Where are the gaps? What don't people seem to yet know? Where do we need to do more work? And of course, there'll be the outcome of the casework that we undertake when people get in touch with us with concerns. We'll also work with charities positively, positive engagement, following the outcome of decisions that we make, and together with fellow regulators, we'll be out there promoting good, better and best practice. Finally, let's just remember that what's good for donors will be good for the beneficiaries of the services that you run and provide as charities. There is no difference between the two, or there shouldn't be. Thank you.